Well, hey there. Good morning or good afternoon, I guess, whenever you're watching this, to my AP Government students. Sorry I can't be there with you today, but I'm going to give you a quick video just to get us caught up on the 14th Amendment. So that way we'll be ready to launch into civil rights next time I see you. And then we'll be able to test before winter break. So that's the goal. Before we do that, I do need to finish up some civil liberties stuff just to make sure that you have everything that you need as far as the Bill of Rights goes. So, just to finish up the Bill of Rights real quick, that's where we're going to start. Then we'll dive into a couple clauses in the 14th Amendment, and that'll be it. So, the Ninth Amendment, I think, is where I left off with some of you. The Ninth Amendment is a little funny. You don't hear much about the Ninth Amendment. Some of the actual text is over here. In this image. But basically, it says, hey, just because we wrote down a whole list of freedoms that people have in the Bill of Rights doesn't mean that there aren't other freedoms. And I realize that's a double negative, but basically, they're saying, hey, other freedoms can still exist, even if we didn't write them down in this list. So this is like a catch-all for anything that the framers may have missed when they were writing the Constitution. That was a big concern of James Madison. He was afraid, hey, if we write down a list of people's rights, they might think that those are their only rights. We don't want that. So the Ninth Amendment is supposed to be there to catch any of those unwritten freedoms that the Bill of Rights should still protect. The way this plays out, a couple of Supreme Court cases, one very important one. The first one, Griswold versus Connecticut, creates what's called a right to privacy. The Supreme Court realizes that there isn't a right to privacy listed in the Bill of Rights, but when they're examining the issues in this case, they decide, hey, we think there is a right to privacy. We think the other freedoms listed in the Bill of Rights kind of lead us to believe that there is a right to privacy, even though it's not specifically mentioned. So we're going to go ahead and say that there is one. That creates a foundation for one of our landmark cases, Roe versus Wade. Roe versus Wade takes state laws against abortion and rules them unconstitutional. It establishes that line that we've talked about in class before of viability, that women should be able to access abortions before that line of viability. And so Roe versus Wade builds on Griswold versus Connecticut with the right to privacy. And of course, out of Roe versus Wade comes pro-life and pro-choice movements. The logic behind Roe versus Wade is, hey, this is a private decision between a woman and her doctor. We've talked about the 10th Amendment plenty before. We've got the reserved powers clause here. So Amendments 1 through 9 are all about individuals. Amendment 10 is all about the powers of the state. So state powers versus national government powers. And remember, we've got our two philosophies here, dual federalism and cooperative federalism. If you believe in dual federalism, you are going to want state powers to be strong and protected. You're going to want the national government to stay out of state affairs. If you believe in cooperative federalism, you're going to think that the national government and state governments should work together. So we've seen the 10th Amendment a lot, so I won't spend too much time there. Let's jump into the 14th Amendment. We're going to talk about three very significant clauses in the 14th Amendment. The 14th Amendment shows up on the AP exam more than any other amendment. We're going to see why, because there are three very, very important clauses out of this amendment. First, we're going to take a look at the Citizenship Clause. The Citizenship Clause defines exactly what it means to be a citizen. Basically, it says, hey, if you are born in U.S. jurisdiction, then you are a U.S. citizen, or you can become naturalized. Naturalization is the process you go through to become a citizen. So two ways to become a citizen of the United States. The easy way, be born in U.S. jurisdiction. That means being born on U.S. soil in one of the 50 U.S. states, in a U.S. territory, or to be born to at least one parent who is a U.S. citizen. Or you can be naturalized. That means you go through that formal process where you weren't born a citizen, but you go through the process of becoming one. The 14th Amendment says you are a citizen both of the United States and of the state in which you live. So you're a citizen at the federal level and the state level. One of the reasons for the citizenship clause was to directly overturn Dred Scott versus Sanford. We've talked about this case a little bit before. Dred Scott versus Sanford is before the Civil War. It's a case where the Supreme Court said that African Americans, whether slave or free, could not be considered citizens. It's widely considered the worst U.S. Supreme Court case ever ruled, and it gets directly overturned by the Citizenship Clause. Remember, we said a constitutional amendment can overturn a Supreme Court case. This is one of the best examples of that being the case. Certainly, there are other impacts as far as the Citizenship Clause goes. This plays a role in sort of the ongoing immigration debate because we have what's called birthright citizenship in the United States. That means even if a person is not a citizen, if they are in the United States and they have a child, that child is a citizen. There has been discussion in some circles about trying to challenge that interpretation of the Citizenship Clause or trying to change it. But for now, that continues to be the interpretation of the Citizenship Clause. So anyone born or naturalized in the United States is a U.S. citizen. All right, let's move on to one of the other very important clauses in the 14th Amendment. This clause gets asked about frequently on the AP exam. This is the Due Process Clause. We've talked about the Fifth Amendment before, which deals with due process, proper procedure for if your life, your liberty, or your property is going to be taken away. The government has to follow these due process protections. The 14th Amendment takes very, very similar language to the Fifth Amendment and then applies it to the states. This is the foundation. This clause is the foundation for this process we've talked about before, selective incorporation. Remember, in the Supreme Court case Barron versus Baltimore, the Supreme Court said the Bill of Rights does not apply to the states. States are responsible on their own for making sure that they protect people's freedoms. Selective incorporation is the process of overturning piece by piece Barron versus Baltimore. So the Supreme Court would take on cases related to the Bill of Rights, and they would gradually apply those freedoms listed in the Bill of Rights to the states. So that's called selective incorporation, or sometimes called the incorporation doctrine. You no longer need to know for the AP exam, Gitlow versus New York. It was the first example of incorporation. Basically, what the Supreme Court did in Gitlow versus New York was take a look at this clause in the 14th Amendment, the Due Process Clause. And they said, hey, wait a second, this seems to imply that the freedoms found in the Bill of Rights now apply to the states as well. So under Barron versus Baltimore, that wasn't the case, but the Constitution has changed. That means our interpretation of the Constitution needs to change as well. So they used the Due Process Clause of the 14th Amendment as a justification to start telling states, hey, you need to follow the freedoms listed in the Bill of Rights as well. So some examples, some of these very important cases that we've talked about before, some that are likely or possible to show up on the AP exam: Engel v. Vitale, Wisconsin v. Yoder, dealing with the First Amendment; McDonald versus Chicago, dealing with the Second Amendment. We talked previously about Mapp versus Ohio, Miranda versus Arizona, Gideon versus Wainwright, dealing with the Fourth, Fifth, and Sixth Amendments, respectively. And now it's the federal government's responsibility to enforce and deal with people's basic liberties, those individual freedoms found in the Bill of Rights. All right, and the last thing for us today, the Equal Protection Clause. So if the Due Process Clause deals with civil liberties and selective incorporation in the Bill of Rights, the Equal Protection Clause is sort of going to be our bridge into talking about civil rights. So Due Process Clause with civil liberties, Equal Protection Clause, civil rights. So the Equal Protection Clause says, hey, no state shall deny any person equal protection under the law. And the way this gets interpreted is the Supreme Court identifies these suspect classes. So things like race, ethnicity, national origin, gender, sexuality. The court establishes a test. Remember, we've talked about this before. The Supreme Court loves a test, and they call this strict scrutiny. It's another way of this phrase that we've talked about before. Does the government have a compelling interest? So what that means is if the government's going to make a law, make a rule that seems like it harms or singles out one of these suspect classes, they have to show that they have a compelling interest in making that law, making that rule. That's a very high bar for the government to meet. So if a law or a rule is going to be passed that's going to unfairly harm someone in one of these identified groups, then the government has to show, hey, here's why we're doing this. We're not just doing this to be discriminatory. We have a compelling interest. And again, that's a high bar for the government to meet. So discrimination coming from the point of view of the Equal Protection Clause can really come in two ways. The first and the easier to identify is discriminatory intent, where the law is written in such a way that in the law itself, it singles out these particular groups or these suspect classes. So if the law is written in such a way that it discriminates, then that's pretty obvious. That's pretty clear. The one where things get a little more fuzzy is discriminatory impact. If the law is written in what seems like neutral language, but then the effect of the law is discriminatory, it can still be considered a violation of the Equal Protection Clause. The discriminatory intent side of things is a little bit easier to see. You can see it kind of written into the law itself. Discriminatory impact is a little bit harder to prove because the text, the language of the law itself can be neutral, but the actual effect of it can still be discriminatory. And then this term, affirmative action, this is a term for government programs that use race as a determining factor to help remedy past discrimination. So the way this plays out a lot is in employment and hiring or in college admissions. Race can be used as a factor to help make a decision. However, you can't establish a sort of quota program where like for college admissions, you can't say, okay, X percentage of our incoming freshmen will be this race, Y percentage will be that race. That is not acceptable according to the Supreme Court. So you can use race as a factor when you're making those decisions, but you can't create a quota system. So again, Equal Protection Clause is all about civil rights, which we're going to spend next class on. Due Process Clause is all about civil liberties and the Bill of Rights. And all of this is coming from the most important, most asked about amendment in the Constitution, which is the 14th Amendment. So next time we'll get into civil rights. We'll knock that out. We'll test before winter break, and then you guys will have a happy holidays. So I will see you all next time.